Welcome, everyone. My name is Rashid Darden. I am so grateful that you have all joined us here today for this program celebrating World Intellectual Property Day, Protecting My Brand. Whether you are a creator or whether you are a practitioner, we're so happy to have you here. Um, Again, I'm Rashid Darden, and I'm the national president of Gamma Xi Phi, the nation's leading fraternity for artists. We are artists of color, and we are artists of sincere allyship. We were founded in 2010 at Ramapo College of New Jersey, and we have expanded since then from coast to coast to be the nation's leading organization providing artistic service and artistic leadership development to our members. And we are so happy and so excited today that we are being joined by the men of Sigma Delta Tau Legal Fraternity Incorporated. And I am pleased to introduce my colleague in professional Greekdom, the Chief Justice of Sigma Delta Tau, Sheldon A. Smith. Sheldon?
Good evening, everyone. Check to make sure I'm not on mute. Okay, I'm not. Good evening, my name is Sheldon Smith. I am the Grand Chief Justice of Sigma Delta Tau Legal Fraternity, the Grand Chapter, which is the national chapter of the fraternity. Sigma Delta Tau was founded in 1934 to promote scholarship, professionalism, and fraternalism in the study, practice, and procedure of the law. It is the oldest continuously existing predominantly African-American legal fraternity in the United States. Our membership is comprised of law students, lawyers, judges, legal scholars, and other legal professionals dedicated to forwarding the purpose of the fraternity. For more information or to contact us, visit sdtlegalfraternity.com. We are proud to co-host this event with Gamma Xi Phi. Thank you, Rashid, for this opportunity for us to collaborate together. Hopefully this is not the last time. Thank you to the Sigma Delta Tau members who are serving as speakers, Bradley Thomas, William Jolley, and Joe Drayton, who I must also recognize as a past president of the National Bar Association. And thank you to Shaina Magrone of Gamma Xi Phi for serving as our moderator. With that, I now turn it over to Shaina. Thank you.
Okay, thank you so much to Rashid and Sheldon for those awesome opening words. I want to welcome everyone to this event tonight. Thank you so much for joining us. We are in for an excellent, open discussion. So excited to be here. So I want to tell you a little bit about me, tell you a little bit about World Intellectual Property Day, and then we're going to get into the heart, the nitty-gritty, the meat of this panel discussion tonight. So as I said, my name is Shaina Magrone. I am the founder and managing attorney of Artisan Law. My firm specializes in business law and intellectual property, and we help creatives and business owners to build their brand, build their vision, and to protect their vision. I am also a member of the Delta chapter of Gamma Xi Phi. Okay? So let me tell you all a little bit about World Intellectual Property Day. You know, every year WIPO has this day. They have a particular theme, and I'm going to tell you a little bit about it. And it's really meant to raise the awareness of intellectual property within our communities and the ways in which we can use intellectual property to further our respective goals, right? So the theme this year is on IP and small and medium-sized enterprises, right? Taking your ideas to market. That's the overall theme. Well, I'm going to expand it, right? We're going to expand it to creatives because we know that creatives can be business owners. They may not be business owners. There's interlap, there may not be. But the point is how can we all, in whatever our respective capacities are, use intellectual property now in this burgeoning, amazing environment where we're moving into this new phase with COVID. We're moving out of COVID. We have all of these new opportunities in a changing world. How can we use IP in order to make sure that our brands are protected, that we can maximize and monetize our brands to the fullest extent, and that we have the knowledge necessary in order to do those things? So that's what this panel is here for. We're here to give you some background knowledge about IP, talk to you about some pitfalls, some stories that we may have this open discussion, and of course, answer your questions. So I hope that you all are going to be really busy in that chat box, giving us those questions, telling us those things you want to know, so we can be here, the panelists can be here to answer the questions and address the issues that are most pertinent to you. Okay. So what I'd like to do next is I'd like to ask the panelists to introduce themselves, right? We want you to know who they are. And we want the panelists to tell you a little bit about themselves, their practice areas, what, if any, specialties they may have. And after that, we're going to get into some just general questions and then move into questions from the audience. So, panelists, if we could start with Joseph Drayton, if you could introduce yourself to everyone on the Zoom, let us know who you are, a little bit about yourself.
Okay, well, I'm Joe Drayton. I am a partner at Cooley LLP, and I've been practicing intellectual property law, counseling, litigation for, I suppose, now 23, close to 24 years. I just want to acknowledge that I saw Kevin Judd on this call, and he's a past president of the National Bar Association. And Juan Thomas is a past president as well, so I just acknowledge them. But happy to answer questions. The one thing I will say is at my law firm, we have something called Cooley Go, and you can look it up, and there's a lot of good resources that are free for folks who are innovators, creatives, starting out in small businesses and things of that nature. But I'll stop there. And thank you for having me. Let me just say that.
Thank you so much, Joe, for joining us tonight. What about Bradley? Bradley Thomas, please tell us who you are. Introduce yourself.
Sure. Hi, everybody. I'm Bradley Thomas. I'm from Washington, D.C. I worn a lot of hats over my time as an attorney and in other capacities as well. I started out in engineering, actually. I was an electrical engineer. I went to Purdue University. I got an engineering degree. Didn't really like engineering that much, but I was good at it. I knew math and science and so forth. So I was pursuing that course. Same time, I was also a musician, songwriter, and in the course of my education, while I was in undergrad school, I was in a group, and we were beginning to tour and record, and heading off into that recording industry, which is sort of a precursor to where I wound up going. And I was always the one in the group who was reviewing the contracts, the recording contracts, the management contracts. I see one of my colleagues from that enterprise is viewing us right now, Willie Jolley, who is the father of one of our co-panelists, William Jolley. And he can tell you that I was always the one who was scrutinizing everything that we had to sign and so forth. And it suddenly hit me. I said, you know, I ought to go to law school and learn how to do this right so we can really make this business happen. And that's how I wound up going to law school. Went to Georgetown University Law Center, and I got my degree and ended up, going into law. First in a variety of fields. I've done just about every kind of practice there is almost, but I've narrowed the practice down now. I do estates and probate. I do some civil litigation, and I do the intellectual property side, primarily focused on copyright issues as they affect musicians, songwriters, record producers, etc. So that's sort of it in a nutshell. There's a lot more detail to the story, but that's the nuts and bolts of it.
Shaina, your audio is not coming through. You're not muted, but maybe there's something on your end.
Can you hear me now?
I sure can.
Okay, good. Sorry about that. So thank you so much, Bradley, for that introduction. And let's go to our final panelist, William Jolley.
Hey, good evening, everyone. My name is Will Jolley, and I'm from Washington, D.C. as well. I went to college at the College of William and Mary, and then I went to Howard for law school. And since then, I've been able to work with creatives. I have some creatives in my family. My name is William Jolley. My father's name is Willie Jolley. He's a motivational speaker and an author. And I've worked with people in my family and other clients who are intellectual property creators. And I just enjoy helping them own their content and look out for their best interests.
Excellent. All right. Thank all of you gentlemen for your introductions. And now let's really just jump into the heart of it. So I really would like to start and have each of you gentlemen, to the extent you want to cover it, let's give an overview of the major forms of intellectual property. You know, copyright, trademark, trade secret, and patent. So please feel free, any of you, to just jump in, cover any part of that, just so we give some foundational information to the audience.
Okay, I don't mind starting off. Trademarks basically cover a word, a phrase, a design. A patent covers an invention, and copyright covers the expression of an idea, a concept, and so forth. Not the particular words, but the way they are all put together, the way the music's put together, the expression of that in the form of a song, a book, a movie, etc. So that's kind of it in a nutshell, the difference between the three. And I'll let someone else chime in.
Sure.
Go ahead, Will.
I'll say a trade secret, for example, the Coca-Cola's recipe for their drink. That would be a trade secreted item. Something that you could reverse engineer to make your own. But if you tried to go and steal the recipe from Coca-Cola, they could get you under trade secret law. And also a trademark could be, I don't know if you guys seen the movie Coming to America. You have the golden arches of McDonald's. That's a trademark. Whereas the gentleman in Coming to America tried to have McDowell's and he tried to have the golden arcs. That would be a trademark infringement. And then patent law helps protect items such as, I think the Super Soaker is one of a great patent that came out years ago, or something that was patented, or something that was created can be patents. So lots of different types of intellectual property.
Yeah, so I'll just supplement, you know, copyright or trademark. When you start to use those things, you may acquire rights in them. And there's something called common law rights. And then there's state rights for copyright and trademark. And then there's federal registration. You can have federal rights depending on how you use a trademark or a copyright. And a patent, I think, has a relationship to trade secrets in the sense, and I think I'll go with Will's Coca-Cola formulation. That could be a patent. You could patent it, but if you patent it, you know, and you're successful, you have a right to exclude people from using that formula for a limited period of time. So let's just say 20 years. And then once the 20 years is up, the patent goes into the public, and that's the exchange for having the right of exclusive use, versus a trade secret lasts forever if no one can discover it. And so without theft. And so for trade secret, you have to keep it confidential. You have to go through great lengths to keep it confidential. If you're successful, then it's your secret and you have a right to it. If it's stolen, you can sue on it, theft of trade secret. But it can last multiple lifetimes, like the Coca-Cola formula. So that was a good example.
Yeah, and the big difference with trade secrets versus the other three is the other three are publicly registered, where a trade secret is something that you keep within your company, within your sphere, and you protect it with confidentiality agreements and contracts and so forth. But the other three are actually registered. And so they are publicly accessible. You can find out exactly what a trademark looks like, what's in the copyrighted material, what's in the patent, but you can't usurp it because it is protected by law, by federal law.
Thank you for all of that, gentlemen. You know, some of the things that you all said I really love, because you kind of talked about how these different forms overlap, how people may use them in different ways. And what I'd like to ask you to talk about is when you've worked with creatives, what forms of IP have you seen them use most? What do you generally counsel them on? And how have you seen it overlap if you have?
Well, I don't actually work with patents. So I can't really, I don't counsel clients on that. I have some friends in that field who are excellent at that, and I would refer them to those individuals. But I do work with trademarks and with copyrights. And again, the difference is that with the trademark, for instance, if you have a logo, a design, that's something you're going to want to trademark versus a song or a book. That's something you're going to want to copyright. So we have to find out what is it that you're trying to protect, and then we put the right instrument to that to get that protection.
Okay.
Yeah. So I mean, look, if you're an artist, you definitely want to protect your name. You know, the name that you use to market your songs and your industry persona, whatever that is. And the reason that you want to do that is because if you don't register it, then you might not have, you might can keep using it, but let's say I'm an artist and I perform in 3 states and I have a name and I've been performing in 3 states for 20 years. And then there's another group that begins to use the same name, but they actually file for federal registration, right? So they're anticipating use across the country. And so you may not be able to exclude them from using your name in that situation because you haven't registered for federal registration. And that's a serious situation because you can actually be evaporated in today's technology if you have an artist that has millions and millions of followers and you have hundreds of thousands of followers. When you start looking at iTunes and the way music is distributed, your followers may not be able to find your music because they're gonna, the more popular artists' music is always gonna come up on searches, and then the businesses are gonna give priority to the artist that has reached the pinnacle of success, not the artist that may be a great artist, may be making money, but just doesn't have the same following. So it is important to register these kind of your trade names, things of that nature.
A practical example of that is the story of Q-Tip versus T.I. Originally, T.I., the rapper from Atlanta, his original stage name was T.I.P., but his record label decided that was too close to Q-Tip, who had come out as a rapper and a producer about a decade before T.I. started his career. And so they asked him to change his stage name from T.I.P. to T.I.
Well, I can give you a personal example of why it's important. You know, it was saying that, you know, I was involved in a musical group and recording group at one time, a long time ago. And in this goes back 4 decades, almost 5 decades, 1974. This group was really starting to take hold. We were starting to do a lot of touring and we had some opportunities to sign recording contracts. So we were called Unity at that time. And what we found out once we started thinking about actually recording was that there were a lot of groups around the country who were using the name Unity. So we said, we need to come up with a unique name, something that nobody else is using, that we can claim, and it can be our name on our recordings. It'll be our trademark. So we came up with the name 98.6, body temperature, great idea. And we decided we were going to go with that name. Well, at the same time, we had a manager who we had for a couple of years, and we were beginning to kind of get on the outs with each other. You know, we could see that there was a breakup coming with that. So the manager ended up, I don't know if we fired him or he left us, but whatever, there was a break. That manager went down to the trademark office and trademarked the name 98.6. So when we decided, okay, we're ready to get on the road, we're going to start this contract, we're going to get on the road with this new name, we went to register it and we found out somebody else owned the name. And it was this manager who we had just ditched. So we called him and said, hey, you know, what are you doing? You know, that's our name. We came up with that name. He says, you can pay me for it. And he wanted some exorbitant price that he knew that we were kids, basically. We were teenagers, and he knew we didn't have that kind of money. So we weren't able to buy it. And so we had to go on and we went on and used the name anyway, but we did not have the trademark protection because he had taken it. Now, it turns out that he didn't renew the name. Under trademark law, in a period of 5 to 6 years, you have to go and show proof that you're using the name in commerce in order to maintain it. And then every 10 years after that, you have to renew it. I see Joe nodding his head. He didn't do that. So eventually he lost his trademark on it, and we were able to trademark it ourselves. But that's a personal example of why it's so important, as Joe said, to trademark your name, your personality, whatever it is that makes you unique in the business.
Shaina, I just wanted to make a technical note for everyone on the that's participating. You may notice that the chat has been turned off. That's my bad. Out of an abundance of caution, I was a little overzealous in the security protections. But I do ask that if you do have a question of the panelists, when Shaina asks for questions, you can raise your hand in lieu of dropping a chat, and then I will just moderate people coming off mute at that time, but only when Shaina is calling for questions. Okay. Thanks.
Thank you so much, Rashid. And please, guys, get those questions ready. I'm waiting for them. I can't wait to do them so we can answer your questions. So I want to thank you, gentlemen, for those responses. And I really appreciate the stories because, the stories really help to illustrate and drive the point home. So please keep them coming. What I've heard from you guys is that it's important, of course, to identify the type of protection you need, from the various forms to register early, and that for some forms of protection, such as trademark, you have some ongoing responsibilities, right? All right. So you all have shared it, a little bit. This is a little bit, I guess, of an, kind of an ethereal question. But I want you to all to talk a little bit about, what does brand protection actually mean to you all? And really, what should it mean to a creator? Go a little bit deeper into those concepts. You've gone a little bit with your stories, but please talk a little bit more about that.
Well, I'll just say that brand is important because it identifies who you are, so or what you've created, and so it's very important. So, Sean John clothing. Right, so we instantly think, okay, Sean Puffy Combs. You think of him picking great designers to create great clothing if you like the brand, and so you instantly associate it with him. Or Rockefeller, you instantly associated with Jay-Z, Rockefeller artist. Okay, and that's important because you want to have that instant connection. And as you build your brand uniqueness, it's important. So you should try to determine if the name you're going to use or how folks will identify you, your service, your product is unique. So you want to think about that. It's reuse over time. So copyright is important because if you have that protection, you may be using it for one purpose, 2000, 2010, a different purpose, 2020. And there's money in that, and I think copyright is sort of synonymous with publishing and music, I would think. So those are some of the reasons why brand protection is so important. Trade secrets as well, knowing that you have the right taste, right? Your product might be identified in that way, and there's a difference between Pepsi and Coke and taste, right? It's not two colas, but distinct tastes, when you have one versus the other. So that's a form of brand protection. I mean, that's why it's so important, because the more unique your product is and the more it identifies the entity that owns it or the individual, the more valuable it becomes over time. I'll stop there and let the other panelists weigh in.
Thank you, Joe.
I would just piggyback on what he said. When you look up the word brand, it says an identifying symbol, just along with what Joe said. And at the end of it, it says it is used to distinguish your product from another. So I'll throw in another word. You're using that brand to monetize. your goal is to monetize. And another example we'll give is that of Nike, the Nike symbol. You see it often, you see the swoosh, and that is their brand of excellence, that, you know, if you get one of their products, that it's going to hold up to their standard of excellence and usability. So that's the same for your brand as an artist. People, you want to have, you spend all this time marketing yourself, looking to put yourself in the best position possible, then you definitely want to make sure that you protect that and that you're able to monetize it. And using these different distinctions are ways to help you protect and monetize your own brand.
And I want to give you another perspective, since you mentioned, Shaina, about using stories, that actual stories. I won't use any names for two reasons. One is confidentiality settlement agreement that's in place, and the other is I don't have the consent of my client to even use her name, even if there weren't this in place. So, but I will tell you what happened. A few years ago, I represented a performer, a singer, who in the beginning of her career, well, right now, she's still in the business, very busy in the business, does recordings and has a name. But in the beginning of her career, she recorded a song, and it was just the jingle and so forth, and with her voice and so forth. Years later, I want to say 25, 30 years later, when the gangster rap industry came into place, that recording was sampled, and her voice was used on a recording that had misogynistic lyrics, that had just really raunchy cursing and misogynistic lyrics, again, that really degraded women, degraded Black people, and so forth. And it was done this way, not just on one, but two recordings by two different major labels. We wound up having to sue both of those labels in a federal lawsuit because her image, she felt, was being denigrated by the use of her voice on these songs. Now, she was a young artist. She wasn't even the original, she wasn't even the author of the song. So in order to get into court, she got the consent of the writer of the song, who also didn't like the fact that his song was being used this way, to file a copyright registration wherein she was listed as a co-owner of the copyright. And then using that, we were able to get into federal court to file a lawsuit that eventually resulted in a settlement where these two labels pulled that product off the market and agreed not to market it any further. In exchange, again, for and some money was also paid to her, but the primary thing was a confidential settlement agreement. So that's why I can't use names of companies or the individual. But that's a true story of how it's important to protect your brand, even if you don't know you have a brand right now. One day you might. Your name, your image, your voice may be a brand, and it's important to protect it.
And brand protection is costly. I would say that, but I want to give you a different spin on this. And I don't know how many of you play golf, but you'll see a commercial for the TaylorMade driver. It's called the Sim Technology. So you'll probably see this more now. I said it if you're not a golfer. And then on the driver face, it has a technology that just curves. The curves are different along the face, so that a bad golfer like myself, or even a good golfer like Tiger Woods, gets a better result no matter how they hit the face of the club to the golf ball when they swing. That is patented technology, right, that they're using to market this golf club. So if this technology is highly effective, that's another form of brand protection, because they can exclude other people from using this twist face technology. And they put a lot of money in marketing. So whether the technology is really doing anything or not, the whole marketing campaign is patent protected. It's another form of brand protection.
Thank you for bringing in that patent point for those inventors who are on this call, or those soon to be inventors. So, I'm hearing from you gentlemen that when we're talking about brand protection, we're talking about creating strong brands that are immediately recognizable to the creator, the distributor, right, of the product or service. That some part of creating that strength is about the uniqueness of the brand name when we're talking about trademark. And we want to also look at, when you're creating your brand, however you're looking to protect it, the ability to expand it over time, to move into different phases, to repurpose it, and of course to monetize it, right? Because in the best of all possible worlds, creators have the ability to express themselves through their respective art forms and then make a living from it, right? So if you all, happen to have, talk a little bit about just some general ways that you have seen artists or helped artists with monetizing. What are some of the things people should be thinking about when we're talking about monetizing your intellectual property?
Well, again, I said I don't really do patents myself, but I can tell you an interesting one about patent.
Doesn't be patent, can be any form.
Yeah. I recently completed a course of study at Harvard University. I got a master's in sustainability and environmental management, and one of the courses I took during that was a course on innovation and technological innovation in a sustainability context. The professor in that class was an individual who originally was from Mexico City, and he was an inventor himself. He holds, I forgot how many hundreds of patents himself. One of the patents that he holds, or held rather, because patent is limited in duration, was a patent for the device that goes in the tire to let you know when the tire is low on pressure. You know, the little gauge you see on your dashboard that lights up if one of your tires is low. Well, this is the individual who invented that. And he was able to market that and to the major tire manufacturers and auto manufacturers for substantial sums of money for a period of time. However, patent is limited to 20 years. And the reason for that is the Congress wants to promote technology development, enterprise, and they want, therefore, that an individual or company can hold on to the exclusive right for a period of time, and then it has to be open to everybody so that there can be more entrepreneurship and so forth. But for that 20 years, he had the exclusive right to the revenue generated from that invention. And so that's significant. You can imagine that little gauge is on everybody's car now and has been for quite a few years. And that's how you monetize your invention.
Yeah, I mean, I would say if have trademark, if you have brands, trademark your brands, because if you have artistic expressions, make sure you register copyrights where it makes sense, because depends on what you mean by monetization. But you want to be able to establish that you actually have the rights in your intellectual property. So if there's an opportunity for monetization, when people are doing their due diligence, they can see that you have paid your registrations, you're actually using the marks, you know, et cetera, et cetera. On the patent side, you know, one patent may not be enough. And so, and you may have a lot of ideas, but you may not be capable of understanding which of your ideas translates into protectable rights, be it patent law or trade secrets. So you really have to seek the advice of counsel to come in, experienced counsel who can help you do IP audits to determine what IP you have and what you need to do to protect your great works, be them patents, or it could be software, it could be some form of artistic expression, but how to best protect it. If you're looking at monetization, that's very important.
So I'll just give just a couple of general examples, right? So, let's say we're talking about a songwriter, and they've, had a concert, or they just have the recording of the song and someone wants to use that. I mean, there are certain boards that are used for songs in particular. When we're talking about monetization, we're talking about someone paying you for the right to use your intellectual property, whether that's your trademark, whether it's your copyright, or of course your patent. Say, for example, perhaps let me use an example of one of the big brands of the big luxury brands, right? Louis Vuitton, for example. Most people don't really know that when you see LV and some of these other brands that are being produced, it's not necessarily directly coming from the LV house. It's coming from other individual smaller manufacturers who have paid LV for various rights to use their brand and their logo, and they have certain specifications that they must meet very strictly in order to use those brands, those various logos, and then collect some profit off of it. Of course, profit going back to LV as well, right? So we're talking about looking at ways that people can pay you for the right to use your name, your goodwill, those things that you have created. That's what we're talking about in regard to monetization. Joe, did you want to say something else?
I mean, I think you're spot on. It's the ability to license your intellectual property, be it a brand name. I mean, that's one thing. You could have a collection of works that you want to monetize and you get paid up front and some other people get the royalty stream for it. I mean, there's all kinds of ways to monetize intellectual property. Most importantly, you have to have it first and protect it. Otherwise you'll get into disputes, which are very difficult to deal with.
Very true.
Yeah.
Joe, I'm so sorry. Who was that?
That was me.
Brad
Thomas. Yeah.
Ahead,
no, I was going to say, and when you're talking about copyright, particularly, it is important that you register the copyright. Now, there's something in the business that's referred to as the poor man's copyright, and that's where you put your song or your manuscript or whatever down, and you put in a sealed envelope and you mail it to yourself with a postage stamp that shows what date you mailed it. Mm-hmm. And that sounds really nice, except it won't get you into court. So if somebody takes your idea, takes your song, takes your book, etc., you cannot sue that person in court because copyright is a federal right, not a state or local right. You have to file in federal court, and you can't get into federal court unless you can show that you have registered that copyright. So getting a poor man's copyright is a good way to stay a poor man in the business.
Thank you for that, Riley.
Yeah.
Will, did you have something? No? Okay. So, so those are some key things to know, guys. For the various types of protections, there are certain things, that you have to do per the federal guidelines in order to receive your full rights, full protections, right? Joe, you said earlier, you talked about the level of expense that it can take to file for your IP and maintain that. Thank you for mentioning that. What I'd like for you guys to talk about in line with that, in conjunction with that, is when is the right time to go after your IP, your brand protection? When should a creator be thinking about it? I know a lot of creators that wait a long time. Various things may come up. So talk to me about best case scenario. When should you start?
Never too early. You should start in the beginning. I've had matters where individuals, again, in the copyright field who did not register copyright until trouble happened. And then they have to rush in and get a copyright registration, and it affects your recovery as well, because you can't get recovery at the statutory rate for a period of time in which you did not have your material registered with the Copyright Office. So you want to do it in the beginning. There's really no reason not to. There's no benefit to waiting until a year down the road or 5 years down the road or whatever. So why not do it up front? Get it done and be protected.
Yeah, and on the patent side, the U.S. laws have shifted in the last 9 years. We were in notice, so you want to file your patent rights as early as possible. Before, we were first to invent, which means you could prove you invented it. Now we're no longer that. We're whoever files first gets the invention. So that's why it's important to file early. The one thing I'll say about trademark registration is you have intent to use, and then you can file actual use. a lot of aspiring artists, creators, innovators file a lot of trademarks that they really are not using. And I think that can be a waste of money unless you truly have an intent to use. So that's the only caveat. But in general, you should file or decide how you're going to protect your intellectual property. That may be a better way of saying it, because you may want to have a trade secret rather than a patent. But in general, I agree, early and often.
Yeah. So there's some
Okay,
strategy.
intent.
Oh, go ahead.
I'm gonna say no. When you do that intent to use, you have to file later within 6 months or so and show that you actually have used, and then you got to pay an additional fee when you do that. So, you know, again, you got to really think about that, as Joe said.
Yeah, there's some strategy that goes into it with the decision of what type to use, and of course, within those schemes, the various schemes for protection, you know, what your decisions are going to be. So I'd like to ask you, gentlemen, if you could give maybe one, I don't know, pitfall story, one horror story you've come across with a client that really helps to illustrate some of these points, drive them home, let people know what happens when you don't do it, when you don't do what we're telling you to do. So I'd love to hear one of those pitfall or horror stories if you guys can share.
I thought I've been telling pitfall stories all along, actually.
You have, that is correct. I mean, you know, if you've got another, great. If not, we will pass the proverbial mic, so to speak.
For now, I'll think about it for a second.
All right.
You know, I'll tell you the pitfall story. And it's really not a pitfall story, but when you have to file for patents, because, you know, when you become successful, your competitors who have patents will assert patents against you. So if you're not filing patents along the way, it just hurts your story. And there are companies out there that are billion-dollar companies, but did not file patents until they like billion-dollar companies, right? So they're competing in spaces with other billion-dollar companies, and they're at a disadvantage from when it's time to tell their story. It doesn't appear as though they're innovative. It appears as though they're a copy. Now, we can adjust that and we can craft a story, but that's why if you have a business, your intellectual property is everything. It's also everything because you create things and you're not always successful in launching a business. Being an innovator and creating intellectual property, you may be very talented at. Executing and turning that into a profitable business, you may be horrible at it. If you actually have the patent, it may not help you in your first year, but maybe 5 years down the road, because you have 20 years of patent rights, somebody else will start using your patent. And then that can be monetized as well. So if you're going to invest and if you put money into having a business, then I would say get the patent and protect yourself. Because if you don't, you'll find you always see these stories about, oh, I had this idea, now somebody has my idea. And some of the very simple ideas are multi-million-dollar revenue generating products because people didn't take the time, because it costs money to patent your ideas.
Absolutely.
So, you know, I thought of the idea of a GPS system 50 years ago. Legitimately, I thought about that long before it was invented. But of course, I had no means to do it. I didn't have the skills. I didn't have the money. And so it was just a thought. Wow, it would be nice if you could put like a little screen in your car and have a signal that bounces off of a satellite, and you could find where you're going and plot your route. Hey, who does not have a GPS system now, even on their phones? So Joe, you're absolutely right about that. But on the copyright side, I've been thinking about that, and one of the pitfalls that many artists fall into is signing off your publishing rights to your songs, to your creative material, and sometimes that's a pitfall that the young artists can't avoid. Sometimes it is a condition of getting into a recording contract, of getting the funding to do a contract and so forth. The record company says, essentially has the artist sign a cohesion contract that says anything you write or produce under this contract, we, the record company, own it in perpetuity. That's happened to me and my colleagues. It's happened to some of the biggest names that you can think of in the business. The Michael Jacksons, the Beatles, the everybody you can think, a lot of people you can think, Taylor Swift.
Prince.
Many young artists signed those contracts.
Yeah.
What was that?
Prince.
Oh, absolutely, absolutely. They signed those contracts because they didn't have a choice. If you can negotiate that, please do, and save yourself a lot of money, a lot of headache. Now, fortunately, there is a mechanism in the Copyright Act that allows you to reclaim those rights after a period of time. It's a long period of time. It's 35 to 40 years, but you can get those rights back. And that's revenue. If those songs are successful, that's revenue that can go on and on and on for your children, your grandchildren, your posterity. But if you can avoid signing such a cohesion contract, please do, because that's a pitfall that gets many, many artists.
Well, I've seen a lot of, it is a delicate balance. I've seen a lot of folks who signed away their publishing who made a pretty good living. And then, we get them out of these contracts and they're not making a living anymore. So you have to balance it and understand the industry.
Yeah, that's a great point, Joe. It is a balance. And it often takes, advice to know what those balances are. And, it also takes, it doesn't always have to be just you. So for example, on the patent side, if you don't necessarily know how to create your vision, draft your vision, there are those out there who can help you do it, and you contract for what your rights are and what you own, Same thing with creating your logo, creating your brand. There are those people out there who will help you to move your creative vision forward, and you contract appropriately for what it is that you own and what becomes yours. So I don't want people to think that just because they don't know how to do it all, and I've seen that be a major issue for people. You think because you don't know how to do everything, then it can't get done. There's always someone out there to help you figure out how to get it done, how to do it properly. And then the point is to make sure that you properly have a contract and agreement in place where it's really clear what your rights are, what's yours and what's not. Okay. So I want to thank you, gentlemen, for this, this opening part, all of this amazing information. I'd really like to open it up to the audience now for any questions that you have. Please feel free to raise your hands. We will be scanning the room. And of course, we can continue to go on talking. Oh, there they go. There go the hands. Yep. There go the hands. Great.
So Shaina, I'm going to take some executive privilege here, and I'm going to jump in front of everybody. But after me, we'll have after me, there will be Sean, Patrick, and Charnel. But Shaina and gentlemen of the panel, I've been thinking a lot lately about visual art. And I'm in a lot of these Facebook groups, and that might be how some of you got here today. And I see people that are drawing, right? It's their own labor. They are actually drawing pictures that are based on photographs that someone else took. And my question is, and I'm a literary artist, so this literally is nothing I am familiar with. Is the person with the pen and paper or the pencil and paper violating someone else's rights by reproducing an image of a photo that somebody else took? And I'll add to that, does the person who is the subject of the picture even own the rights to their own face?
These are tough questions here. Yeah. Very complex, complicated questions.
I thought it was a softball. My bad.
No.
The answer is it depends.
Well, I mean, I think obviously the person who took the picture has a copyright in the picture that they've taken. That's pretty clear. Mm-hmm. I think you implicate potentially right of publicity laws depending on how these pictures are used and the images of the people in the pictures. So that comes into play. And then I don't know, concepts of derivative work might come into play. I don't focus on copyright that much anymore. But I'll let some of the other brilliant minds chime in.
So it does depend, Rashid. It depends upon a lot of things. And there are a couple of things implicated. So for the person in the photograph, have they signed their rights to be photographed, right? That's a background thing. The work that's created, it very well may be infringement, right? Is it some form of derivative work? Is it some form of, there's a couple of things. So it's kind of hard to say. I hate to give that it depends answer. Like attorneys, we do that a lot, but it really kind of does. But the other side, let me say this, the other side of it is, there are times when artists will allow others to infringe upon their work because it brings some level of publicity that they want, right? Whether it's a small or a large artist. So for example, many of the, and let me also say this, there are some people, and I'm not saying for you all to be one of them, but there are some people who just don't really agree with the copyright, trademark, and patent schemes. They have various thoughts about what ownership rights should be and having the freedom of those ownership rights. Okay, so let's put that aside. But for example, large companies in YouTube, and I don't think they do it as much now, but there was a time when they would let their clips be freely shared because it encouraged people to look at their shows and then go back to their platform. So there could be strategy behind it. It depends.
Thank
Anyone
you.
else? Yeah.
Thank you very much. We're going to ask Sean Spencer to provide the next question. Did we lose Sean?
No, I'm here.
Okay.
Can you hear me now?
Yes.
Okay. How y'all feeling this evening? Okay. Well, I am a photographer and I had a couple of different situations. So I was hired once to do a photo shoot, but I was told that the client wanted to be kept anonymous. They asked me, and it was by a company, ad agency, and they hired me to do the shoot. I did the shoot, and I got paid. Everything was great. And then, say 2 or 3 months later, I walk into a conference for my day job, and I saw my work. And I was like, oh man, I did those pictures. And this lady was like, no, you didn't. And I whipped out my laptop and I showed her the raw images and everything. And I remember they asked me to sign away my copyright when I did the pictures. And I said, no, I'll share the copyright with you. But as the photographer, I never give away my copyright. So what I ended up finding out is that they used my pictures in a nationwide ad campaign. And they had billboards and everything done all over the South. And I wasn't trying to sue them or anything. I was just happy because, like you said, that it was giving me a boost in my photography, and it was a lot of free publicity for me. I just wanted to have proof that it was actually my work. So when people tried to doubt it, that I could say, hey, look, this is what I did. And the company ended up being the ACLU. And they were doing a nationwide ad campaign to highlight, before they went to Congress, to highlight the discrepancies in cocaine convictions for crack cocaine versus powder cocaine. And I met this young lady and I took her pictures, and what they ended up doing was superimposing her son's pictures into these empty picture frames that she was holding up. And it was a really big deal for me, and it started helping me get a lot more business later on. But I just wanted to mention that. But sometimes as artists, unless you have a degree in business or taking a few law classes, you don't know. Some people just happy to get a check, so they sign away their copyrights. I took legal environmental business at UDC as part of my undergrad degree. And I remember my professors telling me, never sign away your copyright, never give anybody 100%, ability to use your work. because then, you know, you may never get paid off of.
Thank you very much, Sean. Is there a panelist who'd like to respond to that?
Yeah. It sounds like what you did was license. We talked about licensing earlier, but it sounds like you licensed your rights to this company to do that, and that's perfectly fine. When you first started talking, I thought you were going in a different direction. I thought this was going to be a work made for hire, which would then mean you had no right to claim anything. But if you haven't already done so, you can always register those pictures with the Copyright Office. It doesn't affect the ACLU's right to use them because you've licensed them to use them, but it does give evidence to any other persons who might want to breach your copyright that you are the copyright owner of those photographs.
Thank you very much. Patrick O'Gwen Sr.
Good afternoon, everyone. I'm Patrick O'Gwen Sr. I'm in Maryland. It's good to see everyone here. I used to be an active member of Sigma Delta Tau in the early 90s when Chief Justice Robert Bell and a host of people, Vinny, I know Vinny's no longer here, but he was one of my favorites. So I'm looking to become a little more active again, but I did have a question because you all have touched upon a host of areas, but I'm only going to ask one question. And that is, if any of you can comment, have you used copyright for purposes of protecting computer programs? I'm not speaking of like the code necessarily, but you know, from a patent standpoint or process, but have you used that, for example, to protect computer programs? Have you found some applicability there? If you could give me some comment on that.
Hey, Patrick, good to see you.
Yes, sir. It's good to see you. I saw your name, and that's why I accepted that. I knew this was going to be fantastic. That's why I accepted the invitation.
All right. I haven't done that, but I don't see any reason why it can't be done. I mean, a computer program is an expression of an idea put on paper, put in a form. So it sounds to me like it should be a copyrightable creation.
So computer programs are copyrightable, you know, and they're copyrightable in, you know, a couple of different forms in a couple of different ways. And copyright law has evolved to accept them, right? We know that that's where the world not only is going, that's where it is, right? We all run off of software. The world is moving even further into AI, VR, AR, so on and so forth. So absolutely.
Okay, well, thank you. I haven't used that. I've done a lot of copyright over the years. I've done some really interesting trademark, but I've got a client where I need to consider that. So I may be giving one of you guys a call. I'm on a fast track. I just need to get it done. And I'm a once and done kind of guy, so I like to get it done right the first time. So I kind of hear the essence of that in the presenters, although they've kind of held back a little bit to give us some flow, but thank you very much.
Yeah, in fact, I thought I had something in my notes to that effect. And yeah, the 1998 Digital Millennium Copyright Act does, in fact, deal with exactly that.
Okay.
It's a modification that was put into place about 23 years ago when computer programming started becoming so prominent. So yeah, absolutely.
Thank you very much.
All right.
Thank you, Mr. O'Gwen. Sister Charnel Bryan, Gamma Xi Phi.
Good evening, everyone. So my question, I guess, is pretty simple. I'm looking into taking the steps into copyright and trademark, but what I'm guessing from a lot of people's experience is that the process itself seems very daunting and intimidating. So my question to you all would be, what are just the easiest way to get started? Is it just a matter, or what words of encouragement could you give as far for someone who is intimidated by the process?
Well, I mean, you shouldn't be intimidated by the process. I mean, I think that the governmental websites are very informative. And if you go there, you can learn a whole lot about copyrights and trademarks. I mean, you can actually go and if you take a brand you like, look up their trademark and see how they protect their brand and learn from it. So I wouldn't think about it as a daunting task, because it's really not that daunting. I mean, I recognize most people can trademark their own on their own. Obviously, having an attorney is much better, but it's not, you don't have to necessarily hire an attorney to file a trademark or to register a copyright. So I would do some reading, and I think after you do the reading, you'll feel you have a better conversation with the lawyer and a better understanding of what you're trying to do. But there's a lot of resources online for that.
Thank you
So
very
I would
much.
agree.
Ooh. Go ahead, Shaina.
I would agree with Joe. I mean, you definitely want to start with the governmental sites, right? The USPTO is for patent and trademark. The US Copyright Office, of course, is for copyright. Now, you know, I absolutely do understand that even in reading some of that, you may not get it. So just like Joe said, I mean, you do, to the extent that you have the resources to invest in competent, excellent attorney help to make sure that the process goes the way that you want it to go, because you really can't think that you are doing it right and then you run into a problem. And then you have to find someone to help you unwind the problem if it can be unwound and do it right? And it may end up being more expensive than investing up front to get it done properly, right? But I recognize that everyone may not have that, and definitely emerging artists may not have that. But you want to start there. And to the extent that when you are working with an attorney, you find someone who is willing to educate you on the process, because as far as I'm concerned, an educated client is the best client. You ask us better questions, you know how to address your ongoing concerns, because there are things with many of these forms of IP that you have to do in order to maintain the protection, prove that you have the protection. You know, you want to find an attorney who's willing to educate you and help you along with that process. So I would start with the government websites. You know, and there are, of course, you know, various articles online that will talk to you about the process as well. What I would not recommend is that you go and that you pay some money to LegalZoom to do it for you, because that's going to go wrong in almost every circumstance. I've unwound it for many a client when it goes wrong on the LegalZoom side. Just saying.
Yeah, trademark, you have different classes that you can register trademark under, and that can be a little tricky. So I do think having counsel along the way is helpful, but the more educated you are, the better off your counsel will be as well. So.
Okay. Kim Shala Herbert.
Yes, hi, thank you. I am calling as a brand designer. I'm a graphic and brand designer. I actually am also a web designer. And I am constantly meeting people, if it's from proposal phase to client phase, who are interested in logo design, labels. You know, of course, they're coming with their ideas. And you know, I'm not a lawyer, so I can only set them up or advise that they see a lawyer about trademarking their brand and trademarking their ideas. But, you know, usually I kind of just protect myself and my work. And my question is, what can I do for my clients in that regard? So if I have a client who has me working on a logo for them, but, you know, I know that it has not been trademarked, and, you know, several weeks go by, the logo is finished and I'm delivering the product. I basically know how to protect myself as an artist, but how do I help them protect themselves? Can I put a TM on the logo even though it hasn't been processed yet? Am I allowed to do that on their behalf to protect them as like a preliminary protection? That's my question.
I would advise that you send them to a lawyer. You know, one thing you don't want to be accused of doing is practicing law without a license. And you're kind of infringing on that when you do something like that. So I would advise that you would send them to a lawyer, unless they feel that they're competent to study, as you heard, study the statutes and do it themselves. But I wouldn't, as a non-lawyer, get involved with give them legal advice.
So should I just leave the logo without any mark? Just give them their logo as a final. It doesn't have any trademark on it, and kind of keep it exposed in the time that they're trying to figure out how to go about that process. I'd
give it to them, and again, encourage them to look into what it would take to protect their property, which would include or might include them speaking with an attorney who can assist them. But I wouldn't put the team on it myself.
Okay.
So the logo, I'm sorry, go ahead, Shane.
No, I would just add this. One of the things that we have the fortune of when you're a service provider, and I'm including you in a service provider, is that we have the ability to provide some level of education and encouragement for best practice. We also have the great ability to have an excellent referral network, right? As service providers, we want to build networks with each other for those who don't fit within our category of service that we know that our clients may need, in order to push them along the line of what's going to be the best for them. So I would encourage you, to the extent that you don't have relationships with excellent IP attorneys, to build some of those. We're all here. I know I want to be built with, right? Yeah. And I know the other panelists do as well. So, we welcome these relationships with other service providers, because at the end of the day, it really is about making sure, I know for me, it's about making sure that those of us who are putting our heart and soul into the world get what we're due, and we have that protection, and you need various people to help you do that. So you need to, it's service to push those people along and encourage those things in those relationships.
Yeah, and I was just for the for everyone's sake, I think what you're doing is a copyrighted work, and you're selling it to them, and they're turning it into a service mark or trademark, depending on how they use it. So, and that's an important distinction. So they really have to be the one who take that work that you gave them and turn it into a trademark with the help of the lawyer, or if they do it themselves.
I do within my, and I think I'm doing it correctly even for myself, where I go over my contracts with them about, like, let's say I'm building a website and they're giving me content or they're giving me imagery. And I tell them, look, this has to be original work. This has to be your work. So that, in that sense, I try to protect myself from the work that I'm compiling. But then I also let them know that if I want to use the work, even though I created this for you, if I want to use the work in my portfolio for promotional materials for myself, that I have the right to do that. And I make sure they agree to that. So that's how I even though I created the logo, I'm not the brand. So I'm using it as more a piece. Is there anything more that I should do to protect myself? Like, should I put a copyright on it as my own portfolio work? Because it's just, I'm hired by them to create this for them. So I've done hundreds of logos, but they're not, as much as I claim them, they're not for me per se. So
it sounds like you're talking about works made for hire. So no, that you wouldn't want to claim the copyright, but those agreements that you make, do you put those in writing? You're muted, I think.
Yes, I do.
Okay, so then I'd say that's a good practice, that you should have that in writing, what you're telling them, what you can be allowed to do and so forth, because people's memories are very short when you're just speaking.
Yes.
Right.
Yeah.
Okay, Shala, I would definitely work with a lawyer too, because it's all about contracts. So we don't really know what's in your contract, so it's hard to provide advice on intellectual property, not knowing how the contracts are written. Mm-hmm. But the example is, you can have the same logo used in different contexts, or the same trademark used in different contexts. And so two people can use the same trademark in different businesses that will never touch one another. Nothing necessarily wrong with that. So that's why legal advice is sort of important in this process.
Thank you so much for your question, Ms. Hibbert. Mr. Ogwen, we're going to get back to you because you've had a question. I see Seun Ogunlegan, and we will go ahead and ask for his question. Then we'll get back to Mr. Ogwen.
Good evening, everyone. Thank you for actually putting this panel together. I really appreciate it. I've learned a lot so far. My question to you guys is, I currently have a media company that I've started, but before I incorporated, I had already created a host of content. And I know that in some of that content, I have used previously licensed work. And what I mean by that is that if I'm reporting on a story, I may have used a clip from a local news station or so on to supplement the story that I'm trying to tell. Is there a way that I can retroactively CYOB? I don't know if that's possible, but just to try and, as I try to get more serious about this, I want to find a way to make sure that I'm doing everything correctly. Thank you.
Yeah, I think as long as you give credit to where the sources and you put that in your works, and you can go back and edit your recordings or whatever you have, and give credit to those sources, then you're pretty much covered on that. If the individuals seek some sort of compensation, is something you can negotiate, but you won't be penalized for stealing the works. You may have to pay some fees to them if they decide that they want to charge those, but just cover yourself by giving credit where credit's due.
Understood. Is there a way to do that? As I said, I created a substantial catalog prior to. Is there a way to do that across the board per episode or per filming or what have you, or is it something that I would have to do on an individual basis?
I mean, honestly, that's an interesting question. I don't know that there's a way for you to do it across the board, right? We don't know where you got, the source material from. And we also don't know kind of what if any, licensing agreements there were prior to you using that work. So I would say in general, no, there's probably no blanket way that you're going to be able to do that. I would also say I would encourage you to, I don't know if you actually actively licensed in some way or what it was that you were doing, but I would go back and kind of look to see about any agreements that you may have, or if there's a particular site and there were some terms of use on that site for material. So I would do some investigation into those things.
I'll just give a little disclaimer. I don't think any of the panelists are really focused on giving legal advice tonight.
Correct.
We're just kind of talking about different aspects of the law as we see it. So I'll just put that out there.
So I thank you so much. So let me say this. I should have said this at the beginning. This panel really honestly is just for entertainment and some educational purposes only. We are not, none of us on this panel are your attorney until we are your attorney through engagement. So none of the thoughts here should be construed as legal advice. Okay. If you want to work with one of us, feel free to reach out to us to form an attorney-client relationship where you will receive specific advice to the facts of your matter based upon the facts of your matters that you bring to us. Thank you so much.
Along with an invoice, it sounds like.
Well, you know what, Rashid, honestly, yeah, of course, it is about the investment in our services, but it also really is, we can't give you advice on your specific matter because you bring to us, a 15, 20-second soundbite on a Zoom call.
Yeah.
You know what I mean?
Absolutely.
We have to sit down and counsel you and know what's going on, form a relationship,
right,
and do any work that we need to do, research otherwise, in order to actually give you an answer.
Right.
You know what I mean?
Absolutely. But I also must say lawyers are held in such high esteem. It doesn't surprise me that we have over 60 registrants and at one point 45 participants here just to listen to the expertise of the four of you. So I'll just stop in the middle and say thank you for your expertise and your entertainment. That's what we do here. Legal fraternities and arts fraternities working together for your entertainment. I'm going to go back to Patrick Ogwin Sr. and we'll have Willie Jolley have the final question of the night.
Mhm.
Well, I think my question's been answered by the discussion, and I'm looking forward to hearing Willie Jolley. So I'm going to go ahead and ask you to mute me again.
All right. So before I go ahead, I mean, you know, I did not know that Mr. Jolley would be on this call, but I will say when I was just a young man in DC public schools participating in Future Business Leaders of America conferences, I had the pleasure of hearing Mr. Jolley give a keynote speech. So it is not that many years later, but several years later. So it's my pleasure to have Mr. Jolley ask the final question of the evening.
Mhm.
Greetings to everybody, and I wanted to take a moment first to let you know I'm honored to be on this call because I have two of my closest friends or family members involved in this. As y'all know, my sonny boy is here, Will. That's my baby boy. And then my best friend from childhood, Bradley Thomas, is here. And I just wanted to kind of just give one point. I'm wearing a hat and it says 98.6. And the reason I wanted to share that because Bradley did a masterful job of helping us reclaim our content. We were teenagers when we created this music and it was stolen from us from because we didn't know what we were doing. Bradley got his on. There you go, Brad. And so he did a masterful job of going back, finding the place where we could get reclaim our content, and then doing all the legal work. And he and I worked in unison. I did the kind of marketing on the phone, calling the record labels, making sure that there was no backup, that they would come back after us. Got a clearance from them to say, y'all want to do it, go ahead. And he did all of the filings, and we were able to get all our content back. So I want to applaud him and let folks know that he did a masterful job, and somebody y'all should know is really an expert in this area. The other thing I did want to say, though, I'm a businessman. I built a brand, and I thought it was important that I say to everybody that I built a brand in my books or my TV shows, my radio shows. I built a brand. Now you've talked about a brand today, and there's a little confusion in the marketplace. But when we were growing up, when you said a brand, we thought of a service mark or we thought of a trademark. But today, when you use a brand, what is your personal brand? What is your brand? And each one of you has a brand, and you've got to build that brand, because that is, by its definition, or the way I define it, the piece of real estate you own in somebody's brain. And that is how you build your business. Somebody says, I need this kind of lawyer, or I need that, or I need a speaker. When they think speaker, I want them to think me. And so it's that little piece of real estate that you own in somebody's brain. And I like to use it in this thought. If I said to you, Pizza Hut, what do you think? Pizza. If I say to you KFC, what do you think? Chicken. If I say to you McDonald's, what do you think? Hamburgers and French fries. If I say to you Boston Market, what do you think? At one point they were Boston Chicken, and then what they tried to do, and their stock was going up like crazy. I was keeping my eye on it. Then one day they said, let's be all things to all people. And they went to Boston Market, and their stocks dropped like a rock. And they got sold for pennies on the dollar to a big conglomerate because they tried to be all things to all people. And what I want to say is that a brand cannot be fuzzy. It needs to be clear. It needs to be concise. So when people think, bam, they think of you. And so I just wanted to close with this question to the panel, of which my son is one. As a content creator, books, radio, so forth, and I want to create a brand that is able to sustain me, not just in this lifetime, but 100 years from now, that somebody will say this content was created. What's the time limit that I have on that brand? How do I sustain it for 100 years? You know, the Japanese set goals for 100 years out. And so I've been setting my goals for 100 years out now. So what are the things I need to do to protect myself 100 years from now so that my children's grandchildren will benefit from my intellectual property?
Well, Willie, glad to see you. You know, fortunately, a trademark as opposed to a copyright or a patent can last forever. So you can once you establish your trademark and you renew it, you have to file that you're using it, as I said, within a 5 to 6 year period of time. After that, every 10 years, all you have to do essentially is say, I'm still using my trademark, or your children or your grandchildren, we're still using that trademark. And that can go on and on and on. A copyright, you know, you have the life of the author plus 70 years generally, or for patent, as we heard before, 20 years. But trademark, as long as you're using it, as long as it's out there, as long as it's Willie Jolley Worldwide is in the world, it's a trademark that can go on forever.
Great. That's good to know. Thank you. That's my goal.
Let me also say this. First of all, it's such a pleasure to see you, Mr. Jolley. Oh my goodness. What a treat tonight. Woo.
My pleasure. My pleasure.
So the other thing that I would add, Mr. Jolley, is that when you're talking about the generational wealth and the passing on of your IP for generations, you're talking about the intersection of your IP with your estate planning. Okay. And you're looking at certain things so yes, there is a cutoff time limit for copyright, but it extends beyond your life. And so you're going to need to be thinking about who is it that's going to be your heirs, and what planning instruments are you going to be using in order to pass those things on? Not just your will. Are we talking about trusts? Do you have a business? Do you have a business succession plan? Same thing for your trademark, right? What steps are you taking with your estate planning side to make sure that those assets are going to be properly owned and administered for generations to come and can bring in income for those generations to come? So it's an intersection of things.
That's awesome. That is so awesome. Just so you know, my wife, with her brilliance, has already set that up point. And Bradley's daughter is our executor, and she is a brilliant young lady. And she's our executor for 50 years from now, when I'll be singing with the angels. And so I told her, you just make sure that we find a way to keep that whatever IP creating revenue, so we can make sure we get some scholarships and some resources to people of great need in our community. Thank you for that. You're a brilliant young lady, and I'm so impressed with you. You got it going on, girl. I tell you, I'm impressed with all your comments tonight. Y'all are good.
Mr. Jolley, that means so incredibly much coming from you. Thank you very much.
You're brilliant.
Well, ladies and gentlemen, we are winding down. That was our final question of the evening. And I just want to say what a pleasure it has been. I'm going to let Shaina have the final word of the evening, but I want everyone to know what a pleasure it has been to work with our brothers in professional Greekdom, the men of Sigma Delta Tau Legal Fraternity Incorporated. If you would like more information about them, their website is sdtlegalfraternity.com. If you'd like more information about Gamma Xi Phi, we are GammaXiPhi.com, GammaXiPhi. Sheldon, in particular, it has been great putting this together with you. And to our panelists, thank you so much for giving your time. And we look forward to seeing you out here in some form or fashion when it is safe to do so. Sister Shaina, I will let you close us out for the evening.
Absolutely. You know, I just want to end the evening with a bunch of heartfelt thank yous. Thank you so much to Sheldon and Rashid for being the powerhouses behind bringing this amazing event of service together. Thank you so very much. I want to say thank you to our illustrious panelists, to Joe, to Bradley, to Will, for volunteering your time to come here and have an open discussion with us tonight so that we can unity and raise the vibration. I want to thank everyone in the audience for coming and spending this time with us. I hope that you have gained something. I hope that you've gained a lot from this conversation. If you had a question, I hope that it was answered. And I also hope that it raised some additional questions for you about your creativity and your artistry and what you're going to do in order to protect it, to monetize it, and to make it move forward for generations. And last but not least, I want to thank Mr. Willie Jolley for joining us on this call tonight and being here with us. It has been such an honor, such a pleasure, such a treat. Thank you everyone for being here with us tonight. Have a wonderful evening.